Good morning, Your Honor, and ladies and gentlemen of the jury. My name is Jennifer Doe, and I stand before you today seeking justice in the matter of a civil violation of my rights to privacy. On or about December the 1st of 2014, UA Hospital received a court subpoena for my medical records to be relinquished to the court for review in another civil matter. The subpoena was not accompanied by a court order. The hospital representative has testified here in court that in accordance to the HIPAA Act, in an article that was written by Patricia Orzaga, HIPAA privacy rules protecting patient information requested through discovery, subpoenas, and court orders found in the Employees Benefits Journal of 2004 and retrieved from ProQuest database states, a health plan may also disclose protected health information in response to a subpoena, discovery request, or other lawful process that is not accompanied by a court order. However, certain requirements must be met, and it is my contention that the hospital did not in fact meet those requirements, specifically the satisfactory assurance portion of the Act. The assemblage seeking the Act must have made reasonable efforts in giving notice to myself, the plaintiff. No such efforts were made, Your Honor and jury, and the representative has brought no evidence forth to this court to show that any reasonable effort was ever made to give notice to me. It is my testimony under oath that I never at any point in time received notification that my health records were being subpoenaed by the court or that the records in question were being released by UA Hospital. The HIPAA Act also specifies that reasonable efforts have to be made to secure a qualified protective order. The UA representative has not offered any proof to this court that my health information was not used for any other purpose than that for which it was requested, and has offered no proof that the medical records were either destroyed or returned to the hospital once litigation for that case had ended. Your Honor, I submit into evidence a copy of the HIPAA Act with the highlighted requirements. This is the HIPAA Act, Your Honor. You can see in pink that there are requirements within the Act, excuse me, Your Honor and jury, that have been highlighted. And I submit this into evidence as evidence number 1. It is also my contention that the issued subpoena did not include any reasonably specific description related to anything other than the medical records pertaining to the injury that I had received and was treated for on July the 5th, 2014. HIPAA Administration Simplification Regulation text documents or items required to be produced as included in HIPAA Privacy Rules, portion 1320-5. I retrieved those from hhs.gov. According to the Department of Health and Human Services, a subpoena under this section must be served by delivering a copy to the natural person, that would be me, named in the subpoena, by registered or certified mail addressed to the natural person at his or her last known dwelling place. It is my testimony that at no time did I receive a copy of the subpoena, and the UA representative has produced no evidence to show that an effort was made at any time to deliver a copy of the subpoena to me. I only received a copy of the subpoena by going to the courthouse and paying the court clerk at the district court for a copy. I submitted to evidence a copy of the subpoena, which is right here, Your Honor and jury. This is a copy of the subpoena. And you will see that there's no HIPAA rules included in the subpoena. In addition, the representative did not offer into evidence proof that the hospital maintained a listing of disclosures pursuant to this exception under the accounting provisions in the rules. Now, under those rules, a covered entity must track disclosures made for certain purposes, including the exception for disclosures pursuant to judicial or administrative proceedings. Specifically, the covered entity must document the date of the disclosure, the name and address of the entity to whom the information was disclosed, and a brief description of the information disclosure. A brief statement of the purpose was disclosed, it was included. Your Honor and respected members of the jury, there was a time in my life when I had mental issues resulting from long-term use of cocaine. I have been clean and sober now for more than 25 years. I am also an employee at UA Hospital and would have preferred that my drug abuse and mental treatment stay in the past where it needed to stay. Because of this disclosure of my medical records, my past is now fodder for every gossip group in the hospital. Can you imagine for one moment the embarrassment that this has caused me? Now my supervisor has determined that I must pass regular drug screenings and I must endure a psychic evaluation in order to maintain my position at the hospital. To have to do these things after living my life successfully for more than 25 years has caused me undue stress. Your Honor and jury members, the case involving my medical records had to do with an injury that I received in a fall when I tripped over some cable wires that were left exposed in my yard. My past drug and mental history had nothing to do with the records that were needed or asked for by this court. Initially, the hospital should have contacted the party who issued the subpoena and informed them that they are prohibited by law from disclosing my confidential information in response to a subpoena that is in the absence of the patient's consent that I never gave. They may disclose confidential information about a person only in response to a court order. If the information is covered by federal substance abuse requirements, the hospital should advise the person that notice ordinarily must be given to the patient before a court may even consider ordering the disclosure. A letter should have been written to the issuing party explaining the restrictions on disclosure. That was the hospital's responsibility to do, Your Honor. The hospital should have been careful that this communication does not confirm or reveal that the patient identified in the subpoena is receiving or has received mental health, developmental disabilities, or substance abuse services. Also, the subpoena provides for a notice of objection, which would have been required if the court had asked for medical records to include my past medical history that included substance abuse or mental health. No such request was made within the subpoena, and those medical records, therefore, should not have been included. I offer into evidence, Your Honor, Attachment A subpoena, where it clearly shows by the pink check mark that the subpoena asked strictly just for the records concerning the injury that I had received and that was being litigated in court on that day. It also, you can notice on the attachment that there is a box that can be checked if the court was asking for records concerning drug abuse, substance abuse, or mental health. That box at the bottom was not checked. Also, the subpoena provides for a notice of objection, which would have been required if the court had asked for the medical records to include my past medical history. The request was not made, Your Honor. Your Honor and members of the jury, the Bill of Rights of the United States of America provides in the 4th and 5th Amendments the protection for the privacy of personal information. You can find this information at law2.umkc.edu, Faculty Projects Trials, under Exploring Constitutional Conflicts. In light of the evidence presented to you upon my behalf, I plead with this court to find that UA Hospital did indeed violate my rights as noted under the HIPAA Act, and as such, render a verdict in my favor. Thank you very much for listening.